billionaire CEO laughed in a courthouse hallway and told her attorney, loud enough for me to hear, that a man like me had no chance. She was right about everything except one thing, what kind of man I actually was. My phone rang on a Thursday morning. It was my lawyer, Gina Park. She said the custody modification had been filed and my visitation was suspended effective immediately. I knew exactly what this was about. 7 years earlier, I was sitting in a plastic chair in County Family Court, Room 7, on the 4th floor of a building that smelled like old carpet and fluorescent light. The chairs were the folding kind. Metal legs. The kind that leave marks on your palms if you grip the armrests too hard. I didn't grip them. I sat straight. My name is Joel Reyes. I am a quiet man. I read documents carefully. I never explain myself until I'm ready. The date was March 14, 2017. Cora was 6 years old. My wife, Helen, was waiting at home with our older son. She had made me coffee before I left and said nothing. She didn't need to say anything. The woman across the table was Sandra Voss. She was the CEO of Voss Capital Group, a private equity firm with 43 employees and revenues my entire neighborhood would not see in a generation. She wore a charcoal blazer. She had 2 attorneys. She carried nothing. She needed nothing. Men like me, she had decided, were not the kind of men who win. Her lead attorney was Richard Hale, Esquire. He had a gold pen. He signed things with it the way people sign things when they already know the outcome. The mediator that morning was reviewing the initial terms of our custody arrangement. Voss Capital had acquired the firm I worked for in 2015. Sandra and I had a history that complicated those years. A relationship that produced Cora and then ended badly enough that what came after felt like policy, not personal. She had a different attorney in 2015. By 2017, she had Hale. Hale laid out the proposed arrangement on page 4 of a 47-page document. I will not repeat the numbers here. What I will say is that the arrangement was designed to look generous. It gave me weekends. It gave me summer weeks. It gave me the appearance of involvement in Cora's life while removing every mechanism I would need to actually protect it. I read the document twice while they were still talking. I read it the way I read everything, word by word, line by line, like each sentence is a door I need to know how to close from the other side. Hale watched me read. He leaned toward his assistant and said something I was not meant to hear. I heard it. I wrote it down later. He'll sign. They always sign. The mediator asked if I had questions. I said, not today. Hale's expression did not change, but something in it relaxed. He was already somewhere else. Sandra was looking at her phone. She had a board meeting at 2. This room was a small errand on the way to her real day. The mediator handed me a copy of the proposed arrangement. I folded it. I put it in my coat pocket. I said, thank you. I left. In the elevator going down, I took the document out of my pocket. I had already folded the corner of page 4 at the exact line I needed. Not the numbers. Not the percentages. Something smaller. A reference. Case number 14, CV, 1998, F. It appeared in a footnote on paragraph 6. It was a citation to a precedent Hale's team had used to justify the arrangement structure. I didn't know what it meant yet, but I knew it was there. I knew they thought I hadn't seen it. In the lobby downstairs, Hale was talking to his assistant. He did not lower his voice. He said, tell the Voss office we're done by noon. She can make her 2 o'clock. His assistant typed something on her phone. Hale straightened his cuffs. He looked around the lobby the way men look at rooms they have already decided don't matter. He did not look at me. I walked to my car. I sat in the driver's seat for 6 minutes. I did not turn the key. I took the document out of my coat pocket again and looked at the footnote. Paragraph 6. Page 4. The citation was small. 8-point font. The kind of thing you skip when you're reading fast, when you're confident, when you have a 2 o'clock meeting and a gold pen and a client who has already decided she's won. I did not skip it. I took a photograph of the page with my phone. I sent the photo to myself. Then I drove home. Helen was in the kitchen when I got home. Cora was at school. The house was quiet the way houses are quiet when someone is waiting without asking. She put a cup of coffee in front of me. She sat down. What did the mediator say? She asked. We'll see, I said. She looked at me for a long moment. She has known me for 11 years. She knows what that face means. She didn't push. I sat at the kitchen table with the document in front of me and a pen in my hand. I underlined one thing. Case number 14, CV, 1998, F. Nothing else. Just that. I capped the pen. I set it down. Outside, a bus went past the window. A dog barked twice somewhere on the block. Helen refilled my coffee without being asked. I looked at the underlined number. I did not know yet what I would find. But I knew that Hale had used it, and I knew that Hale did not expect me to notice, and I knew that any number a man uses without expecting you to check is a number worth checking. That was enough for now. That was more than enough. I was already 3 moves ahead. I always had been. Before this gets darker and stranger, hit subscribe, because what's coming next is the part nobody predicted. Not her lawyers. Not the judge. Not even me at first. Stay with it. I went back to work the next morning. I picked Cora up at 3:15 on Wednesday. I made dinner. I read to her at night. A chapter of a book about a lighthouse keeper and a boy who couldn't sleep. Life continued. But at 9 o'clock, after she was in bed, I sat at the kitchen table with a yellow legal pad and I started reading. It was March 21st, 2017. I was looking for case number 14, CV, 1998, F. I found the reference in the court's public index within 2 days. It was a 1998 custody matter. Denlow versus Denlow, filed in the same county, same family court division, decided by a judge who retired in 2004. The case had a published ruling. The ruling was 22 pages. I printed all 22. Then I drove to the county courthouse. Not to file anything. Not to talk to anyone. Just to look. The law library was in the basement. Down a set of stairs, past a service desk, into a room with carpet the color of old mustard and fluorescent lights that buzzed at a frequency that made your teeth feel loose. There were microfiche machines along the left wall. Filing cabinets numbered in red marker along the right. A copy machine at the far end that hummed even when no one was using it. I sat down at a terminal. I typed in 14 CV 1998 F. The file had 43 pages. 3 of those pages had not been digitized. The clerk told me they were in box 14 are in the physical archive. She handed me a request form. I filled it out. I came back on a Friday morning. Box 14 are smelled like dust and old rubber bands. The 3 undigitized pages were at the bottom, under a set of papers from an unrelated matter. Someone had paper-clipped them wrong. I unclipped them carefully. I read them in the archive room with a single overhead light and no one else in the room. Helen called at noon. You coming home for lunch? Late, I said. What are you looking for? Something, I said. Something specific? I'll know it when I find it. She believed me. That is what Helen does. She believes me and makes space for what I can't explain yet. She made me coffee that evening when I got home and sat nearby while I read. She did not look at my papers. She read her own book. She stayed close. That was enough. Cora found me at the table one Saturday morning in April. She was 6 years old. She had her mermaid slipper socks on. Why are you always reading? She said. To help us. I said. To help you. She nodded like that was a reasonable answer. It was. Weeks passed. I developed a method. Every evening I worked from 9 to 11. I kept my notes in a green folder. I numbered every page. I used a separate notebook for questions, things I didn't understand yet, terms I needed to look up, dates that seemed important but didn't fit yet. By May of 2017, I had filled 2 notebooks. I had read 12 custody cases from the same county dating between 1991 and 2006. Most of them were not useful. One of them was. It was Vander versus Vander 2001. Case number 01, FC 221. A custody determination that had been appealed in 2003 and partially reversed. The appeals court ruling, 31 pages, found in box 22Q, which the archive clerk had to pull from a cart because it hadn't been touched in 4 years, cited Colorado Revised Statute 14-10-124, Section 1.5. That statute requires a court to consider the demonstrated pattern of primary caregiving in the 24 months immediately preceding any custody application. It requires that disruption of that pattern be supported by documented justification. I read it twice. I read it a third time. I looked at the footnote in Hale's proposed arrangement. Case number 14 CV 1998 F. Denlow versus Denlow, 1998. The Denlow ruling had used a pre-amendment version of Statute 14-10-124. The amendment that created Section 1.5 had passed in 1999. Hale's team had cited a case decided the year before the amendment that changed everything. Either they didn't know, or they knew and thought I wouldn't find it. I set both documents on the kitchen table. The copy machine in the basement had left a faint line across page 12 of the Vander ruling. I could see it under the kitchen light. I had made 2 copies. I put one in the green folder. I put one in a separate envelope and sealed it. Helen came in from the hallway. She stopped when she saw my face. She did not say anything. I said, "Sit down." She sat. I did not explain it all. I wasn't ready to explain it all. But I called my cousin David, who is a paralegal in Denver, at 10:15 that night. I read him one paragraph. He was quiet for a moment. "Where did you find this?" he said. "Box 22Q, I said. "County Archive basement." "Joel," he said. "The judge never cited this statute. Hale never cited it. It changes everything about how the primary caregiving pattern gets weighted." I already knew that. I said, "Thank you, David." I hung up. I folded the Vander ruling and placed it inside the green folder. I closed the folder. I did not celebrate. This was not the moment for that. The moment would come. But first there was the long part. The waiting, the refusing, the patience that looks like nothing from the outside and costs everything from the inside. Helen put her hand on my arm. "Did you find it?" she said. "Yes," I said. "What do you do now?" "Wait," I said. "How long?" "As long as it takes." The green folder sat on the kitchen table. I had found what they missed. Now came the long part. Year 1 passed. Cora turned 7. She learned to ride her bike in the parking lot behind our building on a Saturday in October. She fell twice and got back up without crying. I held the seat. Helen took photos. We went for ice cream after. The folder stayed on the shelf above my desk. I still had the Vander ruling. I still had the sealed envelope. I did not use either of them yet. I thought about them every day. The first call came in January of 2018. Hale's office contacted Gina Park, my attorney, with a revised offer. More visitation. Every other weekend, plus a full month in summer instead of 2 weeks. 3 additional holidays. Gina relayed the message on a Tuesday afternoon. "They're softening," Gina said. "Tell them no," I said. "Joel, this is better than what you currently have. Tell them no." Gina was quiet. "You want to tell me why?" "Not yet," I said. 3 weeks later, the offer improved again. The summer month became 6 weeks. A small monthly stipend was added. $500 toward Cora's educational expenses. Gina called again. I could hear in her voice that she thought I was making a mistake. "No," I said. "They're going to think you're irrational." "Good." Hale's team sent a letter in March noting that continued refusal to negotiate in good faith could be noted in any future proceedings. I read the letter. I put it in a second folder. It was evidence that they were getting nervous. Nervous people make mistakes. I had made no mistakes. I was still waiting. Year 2. March. Cora lost her first tooth. She put it in a small envelope and left it under her pillow. In the morning she found a $1 coin. She held it up at breakfast like it was evidence of something. I told her it was. Then she said, "Joel, they're broken." "Yes. What do you want to do?" I pulled the green folder from the shelf. I set it on the desk. I had not opened it in 3 months. Everything was still there. The Vander ruling, the statute citation, the 2 notebooks, the sealed envelope with the second copy. "Tell them yes," I said. Now we can talk. The mediation was scheduled for October 17, 2023. Room 12B, 3rd floor, County Family Court. The same building. Different floor. The chairs here were upholstered, blue fabric worn at the armrests. A long table. Pitcher of water nobody touched. The mediator was a woman named Dr. Paula Reed, retired family court judge, 27 years on the bench. Sandra sat across the table. She looked older. Not old, but the 7 years showed. Hale was not there. She had a new attorney, a younger woman named Lena Cross. Cross had a clean briefcase and the posture of someone who had been told, late, that this case was more complicated than it looked. Gina sat beside me. My green folder was on the table in front of me. Dr. Reed opened the session by reviewing the existing custody order, the pending modification request, and the communication history between both parties. She noted that both sides had agreed to mediation in lieu of a fourth contested hearing. She said, "Let's discuss the custody determination." Gina spoke first. She said, "Your Honor, Dr. Reed, I'd like to introduce Colorado Revised Statute 14-10-124, Section 1.5, and case number 01FC221. Vander v. Vander, 2001, partially reversed on appeal, 2003. Cross looked at her notepad. The original custody arrangement, Gina continued, relied on Denlow v. Denlow, 1998, case 14 CV 1998F, to justify its weighting of primary caregiving. Cross looked up. The Denlow ruling predates the 1999 amendment to Statute 14-10-124. Section 1.5 was not in effect in 1998. It was in effect in 2017 when the current arrangement was proposed. The arrangement never cited Section 1.5 and never addressed the primary caregiving pattern in the 24 months preceding the original application. Dr. Reed had the statute in front of her. She read it. The room was quiet in the way rooms are quiet when something is settling. I looked at Sandra. Her expression had not changed, but her hands had moved. They were flat on the table now instead of folded. People flatten their hands when they're absorbing something they cannot push back against. Cross leaned toward Sandra and said something I could not hear. Sandra said nothing. Dr. Reed looked up from the statute. "Counsel is correct," she said. Section 1.5 was in effect at the time of the original application and was not addressed. This proceeding must consider the primary caregiving pattern from 2015 through 2017. Cross said, "We'd like time to review the applicability of." "The statute language is clear," Dr. Reed said. "We'll proceed." What followed was 2 hours. I had documentation for the 2015 to 2017 period that filled 41 pages. School pickups, medical appointments, pediatric records, Cora's preschool enrollment form, parent-teacher conference notes, receipts, timestamps, 417 notebook entries. Cross challenged the weighting methodology. Gina cited the Vander Appeals ruling, page 14. Cross was quiet after that. The final terms were set on November 3, 2023. Primary physical custody. Joel Reyes, 70%. Visitation for Sandra Voss, 30%. Structured as alternating weekends and 4 weeks in summer. Child support, $800 monthly, payable to me. Medical and educational decisions. Joint with my veto authority on major changes. A permanent modification clause requiring new substantial evidence before any future custody challenge could be filed. A protection that would hold until Cora turned 18. Sandra accepted the terms. She did not appeal. Gina shook my hand in the hallway. She said, "You were right. The whole time you were right." I said, "Yes." She looked at me for a moment. 6 years, she said. "Yes. You never doubted it." I thought about box 22Q, the copy machine with the line through page 12, the sealed envelope, the kitchen table at 9 o'clock on a Tuesday evening in April of 2017. "No," I said. "I never did." We walked out. I picked Cora up from school that afternoon. She was 12 years old. She had her soccer cleats in her bag and a permission slip she needed me to sign. She got in the car. She looked at me. What happened? She said. We won, I said. What does that mean? It means you're staying with me. It means I'm your dad. And nobody can take that away. She was quiet for a half a block. Then she hugged me from the passenger seat. We drove home. That evening, I sat at the kitchen table with the final custody order. I read it carefully, word by word. My name, her name, the terms governing the years still ahead. Helen sat beside me. She put her hand on my shoulder. You did it, she said. We did, I said. I folded the order. I did not put it in my coat pocket. I walked to the bookshelf and set it there, between a dictionary and a book about a lighthouse keeper. Not in my pocket anymore. On the shelf, where it stays. The green folder is still in my desk drawer. Not the shelf, the drawer. Some things you keep close even when you don't need them close anymore. Cora is 13 now. She understands more than she lets on. Last week she asked me, Dad, were you ever scared? I said, yes. When? The first day. After that, no. She thought about that. Why not after that? Because after that I knew what I knew, I said. And knowing was enough. She nodded. She went back to her book. I sat with my coffee. I thought about the lobby, Hale and his gold pen, the 2 o'clock meeting, the way Sandra had looked at her phone while the mediator spoke. They had been in such a hurry. That was their first mistake. Patient men are not men who wait because they have no other choice. Patient men wait because they know exactly what they're waiting for. 7 years. 417 entries. 1 statute. 1 box. 1 footnote. Some men fight with noise and anger, and the noise is all they have. I fought with patience, and that made all the difference.